want to start out with, and just to point this out, if you're at the office at Tyson's, they sent out yesterday an email about the procedures for this COVID. And just real quickly for you Tyson's agents, the policy there is the earnest money deposits must be wired to realty title of Tyson's. They are not accepting walk-in or trying to slide checks under the door. Make sure you submit all your contract, and I mean all of it. You won't get paid if there's any parts of the contract missing. They do have a contracts checklist. Look at that. Also with the earnest money deposits, RTS at Tyson's will hold your deposit, but if you don't settle there, it would have to be sent over to the other company. So hopefully you will use RTS title for your transactions. A little warning about that. If you have an earnest money deposit that is for more than what our commission would be, you need to contact the office well in advance so that a check can be cut and sent to the title company for the excess. You can't just walk in automatically and pick up a check. So anytime your earnest money that we're holding exceeds the amount of commission, then that should be something you take care of in advance. And anything that requires the broker's signature, you have to get it to Johanna and to Jocelyn to make sure it's done. And the office hours are restricted. And we have these training classes. We try to set them up for every Wednesday at 11 in the morning. So please follow those. Kevin, I imagine Kevin has some for his office, and Annandale has some for their office. Falls Church has some. So follow whatever your office policies are, okay? Now, some of the things that I received, questions, etc., that I received in the last week, I just want to touch briefly on some of this, and then we're going to take a look at how the COVID thing affects contracts, etc., one more time. Got the question about open houses, okay? Can we hold an open house? I would ask that you be very careful about doing physical open houses at this point. We still have the governor's directive, and under the governor's directive, you can't have more than 10 people at one place at one time. And you would have to figure out how you handle your spacing. There shouldn't be more than one viewer in the house at a time. So how would you do your 6-foot spacing? So just remember, you have to limit interior access. You have all individuals who enter, you should be having them wash their hands or have hand sanitizer there for them. Have extra pens. Everywhere I go, they ask me to sign something, and they're handing me a pen that somebody else has already had in their hand, and I just say, no, thank you. I carry my own pen. But you should have individual pens that they can take with them, or some way to sanitize the pens. So I'd have a bunch of pens that once they sign something, go, or just have your computer and log them in. Ask people for their names and contact information you entered into your own computer so you can reach them. Have all the doors open, all the lights on. Request that people do not touch anything when they are in the property. It's a hands in the pocket showing type thing. Have individuals wash hands or use sanitizers upon leaving. And how you're going to sanitize all the door handles, etc., you have to keep that in mind. So if you're not going to do a virtual open house, but you're going to do these physical open houses, there's a lot that goes into it. Be careful. Now, we've had some changes for this COVID-19. One is the courts. The Supreme Court in Virginia has ruled that all courts will remain closed except for emergency type hearings through June 7th. Okay, but listen to this stat. Just between March 16th, when this started with the courts, through May 1st, the general district courts had 413,000 cases filed, and the circuit courts had 135,000 cases, and an additional 60,000 district court and 19,000 circuit court cases are filed weekly, and they can't do anything with them. So when we're getting into this lease, can I evict someone? They're not even going to listen to an eviction between now and June 7th, and they have such a backlog. You're gonna have a real problem. Also, if a contract is defaulted on, what are you going to do? It's going to take forever. So we're probably going to have to have a little flexibility here. Okay. The state of Virginia, if you're worried about your license, DPOR has said that if your license expires during this COVID close down by the governor, then your renewal is extended automatically. You're still licensed until 30 days after the date that the governor removes the restrictions. So your license is still good. You don't have to worry about that. We are doing continuing ed through NVAR. I just finished it. We'll do it again in June. They are doing Saturday classes only. And the way we do that is they break it up to 4 hours on Friday and 4 hours on Saturday, 2 weeks in a row. Okay. So be aware of that. Now, VAR came out with a new COVID-19 rules and regulations. I did not include this for the class today as far as you printing it out. You can go to VAR's site to get this, but this deals with COVID-19 rules and regulations to meet with what the governor's saying. And I'm just going to briefly cover this form. You can go and download it yourself. And this deals with rentals. So tenants who are subject to mandatory quarantine extending past the end of the lease. What do you do? Do you just go tell them to get out? Well, no, they stay in your rental and they pay a per diem for whatever days they're in past, and they can stay in that dwelling until 15 days after the end of the quarantine. So when the governor says, okay, people, you can go out and move around, then they have 15 days to move. What about, and I got this question several times, do I have to disclose that the occupant had COVID-19, the seller or the tenant? No, you do not disclose that without their written permission. It is not a known material adverse fact about the physical structure or the property itself. And that's what our law says, known material adverse fact about the physical structure or the property itself. So be careful how you address that. It's outside the field of our expertise. That information is important to them. They need to find it out from another source, okay? All rent to be paid online. So these new rules say you can tell the tenant, but it should be in the lease. If not, you'd have to make some other arrangement, maybe even a drop box where they could drop it off, etc. And when it comes to maintenance of the property, there's a shortage of maintenance people that will be able to come out and do the work. And so unless it's an emergency, all that will be postponed to the end of the COVID-19 governor directions. And common areas, there shouldn't be more than 10 people in a common area. So that's the only form change that came out. We will look at our COVID-19 addendum and some of the questions I've been receiving on that. Another thing that I got this week, FSBO, for sale by owner. If my buyer wants to buy a for sale by owner, what do we do? So I asked them to have you download your contract package. And if you did that, I want you to go to page 1, the very first page, and where it says, in this real estate transaction, listing brokerage represents seller, that would be not applicable, or owner representing themselves. There is no one representing them. They're doing it themselves. And the co-op broker would represent the buyer. So if you're going to sell a FSBO, first thing you have to have is a written buyer-broker agreement with your buyer. I mean, I'm not even going to go back and hash that one with you. You know you have to have it, okay? And then I want you to go to the contingencies and clauses addendum, okay? And I'll find a page here for you back here. So it should be on page 27 or 28. Let's see. No, that's financing. I'll get you there. Back on page 33 or about there, it's called contingencies and clauses addendums. And there's one for unrepresented seller or builder and buyer's broker. You need to use this addendum and this clause, okay? Upon seller's irrevocable instructions, it's understood and agreed by all parties that the co-op broker's name, that would be you, and the firm would be Fairfax Realty of Tyson's or what do you call your office, Kevin? Fairfax 66? Whatever. Whatever the office name is acting as an agent solely representing the buyer and the seller to pay the buyer broker fee of whatever dollars, etc. So you need that. Now, in the instance that I got the call, the seller refused to pay any compensation, then you would put 0 in there, but you would make sure the buyer understands they are paying all the commission that's agreed to in your buyer broker agreement. So therefore, make sure it's filled out. My daughter is buying a house in Lake Tahoe out in California, and we found an agent, and I asked him, do you do a buyer broker agreement? So he was really shocked that somebody was actually asking for it. I said, I want you to take care of my daughter. So, you know, I'm going to be looking over your shoulder. So I got their buyer broker agreement, and he was asking for his commission and everything. We have no problem with that. He's working for us. We're going to pay him, and hopefully a lot of it will be reimbursed on their behalf. 2 other things you need if you're dealing with a FSBO, okay? 1, you need a right to show letter, okay? You need to protect you and your buyer when you're in there. Your firm, your office would have to come up with one for you. And our code of ethics says if you are expecting compensation from that seller, that you ask for the compensation at first contact, okay? The other thing you would need the unrepresented party form, the disclosure of brokerage relationship. I'm not going to explain that form over again today. What you do need is that you would check your buyer, because that is who has the representation, and the only party that would sign that form would be the seller. If you are representing the buyer, never let your buyer sign that unrepresented party form. If you are representing the seller, never let your seller sign that form if there's a buyer's agent, okay? If you have a listing agreement. Any questions about the FSBO part? Okay, I am going to also address the issue of a notice versus an addendum. When we talk about this COVID-19 addendum, it is an addendum. Both parties would have to agree, okay? Both parties have to agree. A notice is a unilateral communication that is sent over from one party to the other in accordance with a contract where it called for a notice, like notice removing the home inspection addendum. Then you would use a notice. But an addendum requires both parties to agree. Notice is just putting somebody on the other side. This is what's happening in accordance with a contract, okay? So get it right. When we look at this COVID-19 addendum, just because something has arisen where you don't think you can go to settlement, it does not give either party the right to send a notice to void, okay? You do not have the right to void the contract because you think you can't make it. The contract has to run its course, and at the midnight on the day of settlement, if it hasn't settled, there's no longer a contract. And I'll show you why in our contract here in just a second. All right? So if you will pull out your sales contract form, the package that we asked you to download, I want you to go to paragraph 35, and it is called Time is of the Essence. This you have to understand. You have to go over this with your buyers and your sellers. Time is of the essence means that the dates and time frames agreed to by the parties must be met. Not try to meet it, not a goal. You have to meet it. Failure to meet stated dates or time frames will result in a waiver of contractual rights or will be a default under the terms of the contract. That means that at midnight on the day of settlement, if we have not extended this contract in writing, there's no longer a contract. It's over. It doesn't require releases or anything like that. You want to get a release signed so that the buyer gets their deposit back, but time is of the essence means it has to be done, okay? VAR's contract doesn't have time is of the essence. It's a little, so you interpret it differently, but our contract does. Now I want you to go to paragraph 28 of the sales contract, okay? It should be page 11 of 15 of your sales contract. The default paragraph. Listen to this. If the buyer fails to complete settlement for any reason other than a default by the seller, buyer shall be in default, and at the option of the seller, the deposit may be forfeited. The COVID-19, it's not a surprise anymore. If you're not using the addendum form and your lender's just not ready, or for some reason it was beyond their control, or the home inspection, etc., your buyer's going to be in default. It's not a, oh, well, you know, we couldn't do it type thing. Prior to us all knowing about COVID and expecting it out there and the delays, that would be different, okay? Now, I was asked a couple times, well, if we use this form and it's a multi-contract presentation, then we may not get the offer. Well, I understand that, but you have to understand, this is not a one-way form. This COVID-19 form protects the seller and the buyer, okay? What if your seller can't make it to settlement for something out of their control? Then they would be in default. So if you look at this default paragraph 28, you go down to the third paragraph. If seller fails to perform or comply with any terms and conditions of this contract, or fails to complete settlement for any reason other than default by the buyer, seller shall be in default. So if some reason your seller couldn't make it and you weren't protected by this COVID addendum, they could also have a major problem, okay? So it's not a one-way form, even though it seems like that. Now, if your buyer does not want to, I mean, your buyer decides, because it's going to be a multi-contract presentation, and they decide they do not want to use the COVID addendum form, okay, then I highly recommend, and we discussed this form, okay, and it is the new form by NVAR. I discussed this in a previous session on new forms. It's buyer's acknowledgement of potential adverse consequences, and it's NVAR form K1308, okay? Then I would use this form, and under other, I would put COVID-19 addendum, okay? Because it's in their best interest, I think, to use it with all the uncertainty out there. So this buyer's acknowledgement of potential adverse consequences covers all the paragraphs that they pull out or that would be of an endangerment to them. I like this form. This form is not part of a sales contract. It goes in your folder showing that, hey, we decided to remove these clauses even after you told us we should not do it. Okay, so now I want to cover some of the questions that have been coming up about the COVID-19 form, and then we'll take a look at the form itself one more time. Okay, when can I use the form? Well, you can use it with a new contract, which I highly recommend that if we're representing the buyer, you would do it. If I was representing the seller, I might even be talking to the buyer's agent about the COVID-19 addendum form. Or you can use it after contract ratification, but understand this is an addendum, okay? You can add it afterwards if all parties agree, and they may want to agree because they, think about it. If I'm a seller, I already have a buyer. Do I want to open up my house to more buyers coming in to try to get another contract, or do I want to play ball and extend these dates and give everybody a chance to complete the transaction? I'll probably want to complete with the one I have. So, you can use COVID addendum form, and it would be, either paragraph 3 extending all the contingencies, or paragraph 4 extending certain ones that you want to extend, like settlement date, okay? You can use the addendum form as many times as you want. So if we needed to extend settlement date for 15 days, and we get to the 14th day, and we need to extend it again, then up in the right-hand column of the COVID-19 addendum form, you'll see a number. So it would be number 1. And the next time you had to extend, be number 2. Or you could extend for different things, but each one would be a separate addendum that could extend items, okay? This is only to be used with a sales contract, not to be used with leases, all right? How does the addendum really protect my buyer or protect my seller? Okay, we talk about majeure provisions in the law, and basically what they're saying in common law and in statutory law, if there was a circumstance that arises, an event no human foresight could anticipate, then you might be excused from performing your contract. So in Florida, if we're under contract, a hurricane comes in, wipes out the house, well, then under law, there's not going to be a settlement. Everybody will be released from the contract. And so when this COVID first hit, if somebody couldn't settle and they were already under contract, and then we started having all these restrictions, maybe they could have said, well, this was beyond our control. There's no way anybody could have foreseen this. That's not the case anymore, okay? So when it comes to protection of the parties, okay, we know that there's going to be delays. There could possibly be delays, okay? We don't know if the title company is going to be able to get it done on time, or the courts for recording, or what's going to happen. But we do know that there's the possibility. So your parties are now assuming the risk of not being able to perform with paragraph 35. They know there's this possibility. If you're writing your settlement for 30 days, are you sure they can make it? Because at the end of that 30 days, if you did not use this COVID-19 addendum form at midnight, there's no longer a contract, and they are in default, okay? They are in default at that point. With this COVID-19 form, what it's saying is they're not in default. The contract just ended, and that everybody would, sign the release, and the money would go back because this was outside of our control. But, you need this COVID-19 addendum now. Don't try to rely on that other law. We had one the other day. I got a call, and they were trying to introduce, they were going to miss settlement date, and they tried to say, well, under COVID-19 addendum. Well, there was no COVID-19 addendum. You can't just send over notice that you're going to invoke a COVID-19 addendum. It requires both parties to sign. Okay. This is not a get out of jail free card. Okay. And it doesn't introduce new contingencies to a contract, nor does it put back into effect contingencies that already been removed. Okay. So if your financing contingency has already been removed, the addendum form doesn't put it back in. You're past that. Okay. And think about this. These restrictions on movement, settlements, home inspections, they affect both sides, buyer and seller. What if a seller doesn't want to allow a home inspector physically in their house, or, et cetera? So use the form. I can't imagine not trying to use the form. Okay. Now, impossibility of doing a transaction is not inconvenience, or you don't want to do a remote settlement, or et cetera. That is not what it's all about. Okay. What happens if the unforeseeable event occurs? Does a contract become void? There is nothing in the contract that allows voiding. Okay. Matter of fact, there's only one time in our sales contract that I can find anywhere that a seller would have the right to void a contract. And that is if you request an extension for financing due to Respitala Integrated Disclosure Act requirement by a lender. The buyer can request an extension, but the seller doesn't have to grant it. They at that point could declare the contract void. Otherwise, there's no place for them to void. Okay. Usually the voiding is only an option of the buyer for something like home inspection or for POA or condo docs. All right. But this would not be a default. Okay. So if it was outside of everybody's control, we couldn't settle. People don't have to agree to extend. If they don't, okay, then the contract just dies at midnight. Since it was an unforeseeable event, all parties would sign the voiding of the contract document to release the funds. But otherwise, your party's going to be stuck. They could always agree to a mutual release if there's going to be a problem. You heard the court backlog of cases. It would take you forever to get into court to try to get damages, so everybody should be cooperating. Okay. With the form, paragraphs 3 and 4, when we look at it, those are for existing contracts. You don't fill out a COVID-19 addendum and attached to a contract you're going into right now and already ask for extensions of dates. Just use the date that you think you would take for settlement. Then if you need 3 and 4, we would use it. So what happens if we reach the end and parties won't agree to an extension? I always make sure that you tell your client they still need to talk to an attorney for legal advice. Hopefully everybody would cooperate and we would release the contract. Okay. May the parties use an addendum to extend the buyer's right of rescission under the Virginia Property Owners Association Act or Condo Act? No. Okay. You've heard me talk about this many times. Your buyer has 3 days from the date that they receive the packet or a notice of non-availability of the packet, or if they have not received a notice of non-availability of the packet, they have the right to bail out anytime they want. But you can't extend time periods. I've seen addendums that say, we're extending the time to get the documents to give the people a chance to get them. It's not enforceable. The law says this many days. Now, I will point out, July 1st, the law changes. the parties can agree in writing to make it 7 days, up to 7 days. You can't make it less, so you can't agree to make it less. The law says they have to have the 3, but it will allow you in writing to extend it up to 7 days for the review of the documents. Okay. If you already have a ratified contract, that's what paragraph 3 and 4 would be used for. So if you have your COVID addendum there, let's take a look at it one more time. Okay. Buyer and seller acknowledge that the COVID-19 pandemic may have unforeseeable and indefinite impacts on real estate transactions. This addendum is designed to protect the parties from default. No right to void it, end the contract early unless all parties agree in writing otherwise. But you wouldn't be in default and suffer all those damages under paragraph 28. In the event they're unable to perform due to circumstances beyond their control. It's not circumstances just beyond the control of the buyer, but also the seller. Okay. The addendum may be used during or after contract ratification, used to extend deadlines and settlement date as many times as parties mutually agree. Okay. They define an unforeseeable event. Means any event or circumstance beyond a party's reasonable control that causes performance to become impossible or impracticable. It's no longer a surprise. It's no longer an unforeseeable event unless something new pops up. We know the courts are behind. We know there could be problems with recording. So, but it's in their definition, okay? No default. Buyer and or seller shall not be in default or incur any liability to the other party for any losses or damages of any nature, for any failure or delay in the performance of their obligations under this contract arising out of or caused by, directly or indirectly, an unforeseeable event. So performance, settlement, delivery. I think this form is more going to be used now for paragraphs 3 and 4 than to put everybody on notice that there is a pandemic. I don't know where you've been if you didn't know that exists. So paragraph 3, we have a contract, we use the addendum, things aren't going very well. You put 30 days and everybody's telling you there's no way. So we need another 30, okay? You can use general settlement date and deadline extensions. All the deadlines in this contract are extended, okay? It does not resurrect ones that have already been satisfied. When you use general, that's not bringing something back into play that has already been satisfied. But you're more than likely will use specific extensions. So the following check deadlines or settlement dates are extended by X number of days. So if you check 2 of these right now, then that would be addendum number 1. If you had to come back and extend them again, it'd be number 2, or you could do each one of these as they arise. So look at some of the things you should be discussing with your buyer and seller. One thing we could have a problem with, settlement date. We don't know what's going to happen at the courthouse or how recording is going to go. Home inspection deadline, finding a home inspector that will even go into a home, or will a seller want somebody in their home? Okay, radon testing, financing deadline, well inspection, septic, sale of the buyer's property and kick-out deadlines, or seller purchasing another home. So I would use the COVID-19. So the buyer came in to buy my house, but I said I only sell my house if I can find one. Then as the seller of this house buying my next property, I'm going to insist on the COVID-19 addendum in my contract to protect me, just like the buyer should be protecting themselves. Okay, so, or short sale, in which we might be seeing more of these in the future. So any questions about that COVID COVID-19 form. Don't be bashful, because I keep getting questions all week long. So I'll unmute you guys and see if there's any questions or comments.
I have a question.
Okay.
So what you're saying is we can use this COVID-19 addendum, not checking anything on 3 and 4, and just put the number 1 on top of the right side of the addendum. Everybody sign. Is that okay to start?
Yes. So if you're writing a new contract and using this form, you wouldn't be using 3 and 4. Those are optional until you need them. So the COVID-19 puts everybody on. So what we're trying to do with the addendum form with a new contract is make sure everybody understands if something arises and we can't make it to the settlement, it's completely out of our control. Even though our contract dies at midnight on the day of settlement, that does not constitute a default under paragraph 28 for I'm going to mute everybody again because that's background. See if I can get to it. Okay, so what you're doing with the COVID-19 addendum is telling everybody a problem could arise. When the problem arises, then we come back and use either 3 or 4. If you have an existing contract, it looks like it's going to have a problem, you could always go back and see if everybody would execute a COVID-19 addendum form. That answer it?
I'm on conference call right now. Can I call
Did that answer it, Kevin?
Okay, thank you. Yeah, that's answered. But can we do 1, 2, and 3?
You can use it as many times as you want.
Okay.
As many times as everybody agrees.
So you can. What you're saying is we can use this addendum number 1, 1 and 2, nothing on 3 and 4, and then we can, when we have to use it, then we put number 2 on top and use number 3.
Yes.
Okay. All right.
Or 4. If you're trying to extend all the conditions, you would use 3. If you're just trying to do the one item, it would be that one. And if you need to use it again, you just put another number up there so we have track of all the addendums in the contract.
And this can be used from the seller side too.
Absolutely. This protects both sides. That's why I keep buyer agents saying, well, we don't want to include it in our contract because the seller might not accept our contract if the other ones don't have it. And I understand that, but it protects the seller also. So what I would recommend is if you don't, mute all again. What I highly recommend, and I'm not sure if everybody's familiar with that adverse action addendum form. If you're not using it, I would highly recommend that you start using it if they're going to say, I don't want to use this COVID-19. Any other questions about it?
So Larry, if I understand you correctly, what you're saying is that if I'm putting in a new contract, I should only indicate number 1 on the COVID-19 addendum. Is that correct?
You would put number 1 up at the top of the form where it says number.
Okay. So what about?
And then by having, when everybody signs this addendum form, they're acknowledging 1 and 2. That's why it says optional for paragraph 3 or 4. You wouldn't be filling anything out in paragraph 3 or 4 if it's a new contract. You would just put the days that you think you need in the regular contract. Okay, so if in these trying times, I'm adding days to my contract. Now if it's a multi-contract presentation, everybody tries to play beat the clock. But when you do that, you put your person in a difficult situation if they can't settle, because time of the essence is still there. And they don't have to allow an extension of the contract just because you're not ready to go. They could hold you to the fire. At midnight, that contract is over on that settlement date. They could put their house back on the market and go, when this is all straightened out, go and sue for damages. So this is just trying to, make it so we all playing nice and everybody understands what's going on.
One more question, Larry. So
Okay.
on the dates, I'm trying to get more clarification. So as it says, this addendum is made on. So is it on the date that you signed the contract, or on the date that I'm trying to get an understanding of that.
Okay.
So is it on and then offered on? So can you explain that a little bit more, please?
Okay. So you're writing a contract today, right? May 20th.
Yes.
Okay. And you're going to include this with your contract. So the paragraphs 1 and 2 are incorporated into the contract. Then this addendum is made on May 20th to a sales contract offered on May 20th.
Oh, okay.
Okay.
Well,
now, if you're going to try to use this form after you have a ratified contract, okay, and we're going to have trouble with dates and everybody wants to agree to extend dates, then what you would do is you would say this addendum is made on May 20th to a sales contract that says was done on April 20th, maybe. Okay, so the dates match up. If you're going to use it with your contract today that you're writing, the dates match up. If you already had a contract ratified, now you're running into problems. You want to see if they will agree to adding this addendum and using paragraph 3 or 4 to extend dates, then the dates would be different. But otherwise, right up front, dates would be the same.
Perfect. Thank you.
Okay.
Yes, that is cool. Thank you so much.
All right. Good question. Good question. Any others?
Yes, Larry, this is Ahmed. If we did the addendum and we came to the settlement, the buyer couldn't make it, and the seller would not want to wait anymore, what would we do at this point? Do we have to send something to void this contract, or what would you do?
At midnight that day, there is no longer a contract. Okay. But if they're willing to give them the money back, then use the release of the contract form on page, you don't have to void it because it no longer exists, but in your contracts package, there is on page 18 of my package, right after the walkthrough form, there's a release of the sales contract and deposit form. Okay. So if this thing dies, we still have a deposit. Okay. And even though the contract no longer exists after midnight, because we do have time is of the essence in the contract, you would use the release of the sales contract and deposit to just say, look, this is all over. Everybody agrees it's over, and we're going to give the deposit back to the buyer. Okay. And that's what it's saying. If this form was used and they could not make the settlement, it was outside of their control, then you would sign the release, give them the deposit back, but you don't have to void it. It's already void.
It's really good. Okay.
Now, if they want to if everybody agrees to kill the contract, okay, everybody agrees that this is just not going to happen. We're not going to wait for another, week to find out we don't have a contract. Then you would use the notice to void and send a release. So there's a difference between a notice and a release, right?
Yes.
So in our contracts package, let me find it for you here. There is a notice to void form, and you would always use a notice to void if everybody agrees to void before we get to the settlement date. But once we reach the settlement date, so page 45 of the contracts package, if you downloaded it, so we have a notice voiding of contract form, okay? And anytime you need, like if you were going to void for your home inspection addendum, right? You would use this you would use the notice to void the contract. You have to because it calls for it in the contract. And then you would sign the release. So if everybody wants to kill this contract, no one wants to use paragraph 3 and 4, we're still a week from settlement and it just doesn't look like it's going to happen and everybody's in agreement, sign the release, void the contract, then everybody could void and move forward. But other than that, the release would probably suffice.
Perfect. Thank you so much.
And that's why, anytime you see in a contract say giving a notice, that's a unilateral communication. You have to do it properly, not send an addendum. Okay. Any other questions? Okay, we were going to discuss today also home inspection addendums and releases, but I try to keep these sessions to only an hour. So I think we'll do the home inspection addendum and releases next week. I also want to cover some new laws that will be coming out July 1st. Couple that I just mentioned now, and I'll go over again in another session. July 1st. Virginia's fair housing law changes. They're adding 4 new categories. Okay, 1, sexual orientation. 2, gender identity. 3, source of income, which would be Section 8 that we talk about. And 4th is veteran status. Okay, so there'll be 4 new parts to our law, and we'll discuss those in a future session. They don't go in until July 1st. And also, when it comes to the driving and talking on a phone, handheld phone conversations will be illegal starting July 1st, but they're not going to enforce it until January 1. So get used to getting off those phones, okay? And then the 7 days that you could request for the home POA and condo to review the docs. There's some other ones and we'll cover them. Somebody have a question?
I have a question on rental. If you take a rental listing, so do you still have to have the COVID form?
No, you
form
would not.
signed by
You would-
whom?
No, you would
For
not
showing
use
also.
You would not use the COVID addendum with a rental. Okay. They
And for
have some
showing?
not even for showing. Okay. There's nothing under that COVID that they could have some kind of restrictions they put on showing. Matter of fact, even for the walkthroughs at the end, the landlord, could do a virtual walkthrough. They could be walking through virtually, and the tenant could be somewhere else when they do the walkthrough. So you want to be careful with the leases. The only thing they've really done with COVID with the leases is they've come out with some addendums if people have to request it, a reduction in rent because of loss of job, et cetera, and how they prove it. And then VAR came out with this one that we discussed today about paying the rent online and that type of stuff. But don't try to use this COVID-19 addendum form in rentals. It's
Okay.
for sale only.
Thank you.
Any other questions? Johanna, you have anything else?
Mr. Larry, this is Ahmed again.
Okay.
Can I ask you another question for
Sure.
Residential contract? Can you check both HOA and condominiums, the number 8 and number 9?
Yes, because it could be both. So if there's both, then you would check both boxes. And our law says the right for walking because of the condo and POA. If there's both, then the days don't start until you receive the last package. But like there's some places that have both, like Reston has condos and homeowners association. You're bound by both so you have to receive both packages.
Yeah, I'm doing an offer for a place in Ashburn, and it has HOA fees, but it says condominium.
No, so you would have to receive both packets.
So it should be two. Okay.
Yes, yeah. And the time doesn't start. So if you receive the POA packet first, the time for bailing out doesn't the 3 days you don't start counting until you get the condo package also.
Okay, perfect.
Okay.
Thank you.
And one more question I have is, on the contract you select both HOA also, and you select on condo also, right?
You could, if there's both, you would do both of them, yes.
Okay.
But make sure there's two separate, separate groups. And you could go to the CIC at DPOR, Common Interest Community section of DPOR. They have to be listed, filed their paperwork either there or with the SCC to be in, required to get the documents. So, but if they say on the listing both of them, then you need both packages. Johanna, I see your J up there. Are you there?
Hey, Larry, this is Jocelyn. Johanna's having trouble with her mic.
Oh,
she
so
can hear
J
you
is
and
Jocelyn,
see you.
not Johanna.
That's me. Yeah, she is on, but she can hear you, she can see you, but she can't communicate with you.
She can't talk? That's
She
unusual.
cannot talk. Yes.
Did she text you or let you know if there's anything else she wants to
She
cover
actually
today?
just tried to call me.
You want to see if there's anything else she wants to cover before we call today?
Yeah, let me give her a quick call and see. Yeah, she's calling me.
Kevin, you have anything else you want to cover today?
Kevin, you're mute.
I'm sorry. Can you hear me?
Anything else you want to cover today?
Can you hear me?
Yeah, anything else you want to cover today?
Is anyone here ever used this COVID-19 addendum? Anyone?
I did.
You did? Oh, okay.
Yes, but I already have a contract for that because my client, I'm representing the buyer.
Mhm.
My client was locked out and she was in Philippines. So I need to use this one because I don't know what's going to happen. So I'm supposed to have my closing on March 22nd. So after I have extended it on the normal extensions that we do, I use this one for my last extension, but I will be having my closing already
So
this Friday.
when you use this addendum as a buyer agent to the other
Yeah.
side, what was a listing agent response? Like,
Nothing. They just signed it. Yeah,
Okay.
it's because I told them like the reason why they weren't here, it's because of the lockup and definitely because of the COVID. So they have no other choice but to sign
that's
it.
good. That's
Yeah.
very good. Okay.
And a lot of it, don't go in with the attitude that it's a negative. It protects both sides,
Okay. Yeah.
So, but I can understand, it's something new, and anytime agents see anything new, they don't like it.
That's true.
Yeah. There's not that many people out there really understand how you use this form or what it actually means. So, I'm glad we had this session. Yes, Jocelyn.
I was just going to say that Johanna says, thank you. The class was great. And not to forget, next Wednesday, same time, will be another class and an email will be going out as well.
Okay. And spread the word. We had 25 people today, so that's a pretty good group, but we have a
We
lot
actually
of
see
agents.
28 people. We had a couple of people on phone only.
Okay, so
28. Mhm.
well, the 28 also includes you and me and Nestor. So
We count.
oh, okay.
We're learning too.
It was a good session. It was very good. Thank you, Larry. Thank you,
Well,
everybody.
Thank you.
We'll see
Okay.
everybody next
Thank you,
Wednesday at
Larry.
11,
Yeah.
and we'll go over that
Thank you,
home
Larry.
inspection questions we had. And thank
Thanks,
everybody
Larry.
for
Thank you,
joining.
everybody.
Bye-bye.
Okay, thank you, Larry. Thank you, everybody.
Bye.
Bye.